Good morning, ladies and gentlemen. Let me first of all thank New York University and the other organizers of this meeting for having invited me to give a presentation on the role of international law in dealing with the threat that we are experiencing today with regard to the destruction of cultural heritage by conflict or natural disasters. I am a native of Florence myself, and I have vivid memories of the flood of 50 years ago. I was a student at the University of Florence, and I had the experience of seeing the love of the world, of humanity, toward my city in the reaction that the world had with regard to this event. Unfortunately, although we are surrounded by beauty of the urban landscape of Florence, by the beauty of these wonderful works of art, we are aware that beauty alone is not capable of saving our cultural heritage. We need the law, we need institutions, and we need political action in order to preserve our heritage. So, in my brief presentation, I would like to simply outline the potentiality of international law, the achievement of international law in this field. It took, as you know, the destruction of the basis of civilization of Europe with the two world wars to take the initiative after the Second World War in the 50s to start the development of the legal framework that we have today. And this development was due in large part to Unesco, to the action taken by the Organization for Education, Culture and Science. It was with the first instrument, the adoption of the Hague Convention of 1954, that we laid the ground for the protection of cultural heritage in the event of armed conflict by laying down obligations that all states, parties to the convention, and now the convention has almost a universal scope of application, the obligation, of course, start to apply in time of peace in order to prevent the disaster, the damage in the event of conflict. UNESCO, of course, continued its codification work in this area of the law with the 1970 Convention, Paris Convention on the suppression of illicit traffic in cultural property, movable property, another threat that is posed not so much by conflict but by the dispersion that illicit traffic causes in the cultural heritage. But we have seen that, of course, the illicit traffic is linked also to the situations of occupation of foreign land after the conflict. We have moved to the adoption of new models of international cooperation in 1972 with the World Heritage Convention, which was really facilitated by disasters like the floods in Florence and other disasters in order to mobilize the international cooperation at the level of restoration and financial support for the response that was necessary in the event of such disasters. After this 1972 convention, I would like to point out there was an interesting dynamic that has taken place toward what I call the human dimension of cultural heritage. That is the idea of cultural heritage as not only a thing, an object, something that of course is beautiful or historically important, but as something that represents the spirit, the culture, the living culture of the people. And we have moved in the direction of protecting, or rather safeguarding, not only the products of culture, art and other cultural objects and property, but also the processes that lead to that outcome. That is the processes of social character, political character that characterize a living culture. So with this focus on the living culture, we have come to the adoption of new instruments, such as the 2003 Convention for the Safeguarding of Intangible Cultural Heritage, and finally also the adoption of the 2005 Convention for the Protection and Promotion of Cultural Diversity, a topic that, of course, will occupy your work in the following afternoon and tomorrow. As I said, law is necessary in order to safeguard cultural heritage. But in what way, besides laying down these instruments that I have very briefly mentioned? Well, there is something new that is happening at the level of international law that needs to be recorded and explained here. There is, of course, the movement toward the prohibition of intentional destruction, which found its moment of crystallization in the declaration adopted by Unesco in 2003 following the destruction of the great Buddhas of Damian that shocked the conscience of humanity for the gratuitous and perverse spirit that that sectarian act of destruction showed. But there is another important development that is linked to the outcome document of the summit, the United Nations Summit of 2005. I am referring to the doctrine of the responsibility to protect, a doctrine that has been developed in order to provide a remedy, or even more important, a prevention of mass atrocities, genocide, ethnic cleansing, persecution. Now, that doctrine, of course, is a doctrine that entails that all states must protect their population against such atrocities, against war crimes, against crimes against humanity, and genocide. Now, intentional destruction of cultural heritage of great importance to humanity comes within the scope, in my view, of this general obligation to protect cultural heritage in different ways. First, it entails, it is a breach of the laws of war, entailing state responsibility under the 1907 Hague Convention and of the 1977 Protocols of the Geneva Convention, Articles 53 and Article 85, paragraph 4d. So we are dealing with destruction that amounts to crimes of war already under the existing instruments in force. Besides state responsibility, the intentional destruction entails individual criminal responsibility. This is now a well-established, not only under the second protocol to the Hague Convention that was adopted in 1999, but especially under the statutes of the various international criminal tribunals and courts. Article 3 of the Statute of the International Criminal Tribunal for Yugoslavia has been applied to many cases of war crimes by the Tribunal. But the Tribunal has gone further and has held that when the attack on cultural property is perpetrated with the requisite discriminatory intent, it amounts to persecution, so it amounts to a crime against humanity. There is a third aspect that reveals the relevance of the responsibility to protect doctrine for our topic. That is the practice of the United Nations Security Council that has evolved in the past decade so as to bring assaults on cultural heritage of great importance within the scope of Article 39 of the Charter on the Threats to Peace. Even before the responsibility to protect doctrine was formally adopted in 2005, the Security Council, by resolution number 1483 of 22 May 2003, included the devastation of Iraqi national heritage among the situations determining a threat to the peace and regulating the action of the Security Council under Chapter 7 and bringing all member states to the respect, the obligation to identify the illegally removed object and cooperate toward the return of those objects to Iraq in cooperation with Unesco. The Security Council has adopted similar resolutions in May 2011 with regard to the situation in Mali, and in 2015 with regard to cultural property in Iraq and Syria attacked by terrorists of the Islamic State. Now it is established that the destruction of cultural heritage is not a matter sheltered by domestic jurisdiction under Article 2, Paragraph 7 of the Charter, as in the past could have been deemed, since the treatment of cultural property in the past was deemed to be an affair of the state, to be considered just within the privacy of the state itself. There is a fourth consideration that I would like to present here. At a purely normative level, we must take into consideration the progressive development of the law of state responsibility as a factor supporting the protection of cultural heritage. Article 48, paragraph 1b of the International Law Commission's 2001 Articles on State Responsibility provides that any state other than the injured state is entitled to invoke the responsibility of another state, and here I quote, for a wrongful act if the obligation breached is owed to the international community as a whole. What we see here is that breaches such as genocide, aggression, ethnic cleansing, these breaches invite the response and permit the invocation of international responsibility by any state, because the international community has been able to identify these breaches as breaches of interest that are of the international community as a whole, not involving the interest of any specific state. So if they have come to include also crimes against the environment that impair the life on the planet, we must deem that they today must include also egregious attacks against cultural heritage of importance to humanity. Of course, this is a theoretical tool. Article 48 is only a norm, but the fact that the United Nations Security Council has shown readiness to include attacks on cultural property within the threat to peace gives reason to believe that it may also become an important policy tool for the expansion of the responsibility to protect. Now, for the time that I have left, I would like to just touch on another dimension, different from the one I have treated until now, which is the normative dimension of international law. But that is not enough, obviously. We have also the operational dimension, what can be done effectively on the basis of the norms that I have just tried to explain. Of course, at the operational level, we can make the responsibility to protect doctrine an effective tool only if certain conditions, certain prerequisites are satisfied. But of course, there are certain possibilities here. One, of course, is the action by states. And I would like to mention here the initiative that already the Undersecretary Gilles this morning mentioned. That is the initiative by the Memorandum of Understanding that was signed in February 16, 2016, this year, by Unesco and the Italian government for the establishment of, here I quote, an Italian national task force in the framework of UNESCO Global Coalition Unite for Heritage. The Memorandum of Understanding provides for the rapid mobilization of national experts and cultural operators in areas of crisis, conflict or natural disasters, so as to take preventive action, urgent safeguarding, and remedial measures, especially in order to fight looting and illicit trafficking. This, of course, is a national initiative that reflects the spirit of the responsibility to protect. At a multilateral level, UNESCO has adopted by Resolution 38C-48 of 2015 a strategic plan for the protection of cultural property and the promotion of pluralism. The Director General has a mandate to implement such plan in collaboration with the United Nations and member states. This is an important initiative because cooperation is necessary at the intergovernmental level to give teeth to the responsibility to protect cultural heritage in time of conflict and natural disasters. The third point, of course, that I wanted to mention is the role of education and awareness raising. The role of these two elements can be probably the most important when we try to deal with crimes against cultural heritage and with natural disaster that risk the destruction of the same heritage. This is an area where UNESCO can play a decisive role in keeping with the philosophy of its constitution that is based on the intellectual solidarity and moral solidarity of humanity with regard to the effort that we must make in order to prevent wars and maintain security. The final point concerns the criminal prosecution of perpetrators of cultural crimes. This is an essential step toward a more efficient action to protect the cultural treasures of the world. This entails a greater effort by states themselves to enforce criminal law and exercise their criminal jurisdiction to prosecute and punish criminal attacks against cultural heritage also beyond their borders. The 1999 second protocol to the Hague Convention establishes a form of universal jurisdiction and it goes exactly in this direction. At the same time, besides national efforts to prosecute and punish crimes against cultural heritage, We have to also underscore the importance of international criminal justice as a deterrent against cultural crimes. And the jurisprudence of the International Criminal Tribunal for Yugoslavia and the recent case law of the International Criminal Court in the well-known Almaty case can mark progress in this direction. I would like to close my presentation with an historical reference. Just about a century ago, the Italian avant-garde artist Tommaso Marinetti, the founder of the Futurism, a very important avant-garde movement in the first part of the last century, was advocating the destruction of museums, academies, and all the objects of art, of archaeology, as things that were dead that should be just eliminated. That ideology, besides providing the ferment for this artistic movement, unfortunately became also one of the underpinnings of the action ideology that led to the authoritarian states that were the protagonist of the disaster of Europe with 2 world wars. I think that we have to remind that, to consider that sometimes the destruction of cultural heritage goes hand in hand with the pervasive effects of hatred and war, and that respect for cultural heritage is the best guarantee for the maintenance of peace and security of our international community. Thank you for your attention.
Good morning, ladies and gentlemen. It's a great honor to be here with you this morning, and I thank the organizers for inviting me. It's a great pleasure to be here also because even though I'm based at Lancaster University in the United Kingdom, I am a Florentine, and once a Florentine, always a Florentine. So it's a particular pleasure to be here at home. So this morning I'm addressing a very complex topic, iconoclasm, cultural politics and resilience in international law. So my presentation aims to bridge the gap between different disciplines. And first of all, after defining the concept of iconoclasm very briefly, I will discuss the linkage between iconoclasm, cultural politics and resilience. And then the key question of my presentation will be, what role can international law play in order to fight iconoclasm? I will provide a critical assessment and some preliminary conclusions. First of all, what do we mean by iconoclasm? As mentioned, iconoclasm is not a legal notion, and traditionally it has belonged to the history of art, meaning the intentional destruction of religious icons for essentially theological reasons. However, nowadays it has a far broader concept, and it indicates the deliberate destruction of cultural religious artifacts for a variety of different reasons. So, example of religious iconoclasm abound. It was mentioned just a few minutes ago that, as a matter of fact, even in continental Europe, there were cases of religious iconoclasm. For instance, in the 17th century, some Protestant reformers argued that religious icons could lead to idolatry, and therefore should be destroyed. And there were destructions of cultural heritage. There are, of course, other types of iconoclasm, in addition to religious iconoclasm, for instance, political and even economic iconoclasm. Examples of political iconoclasm include, for instance, the destruction of cultural and religious artifacts during the French Revolution or even during the Chinese Cultural Revolution. But of course, the boundaries between political and religious iconoclasm are blurred, in the sense that oftentimes it can be very difficult to spot, to identify whether a specific destruction constitutes political iconoclasm or religious iconoclasm. So for instance, in the case of the destruction of the Buddhas in the Bamiyan Valley, although the Taliban claimed that they were destroying these artifacts for religious reasons, because these artifacts could be deemed to be idols, as a matter of fact, this destruction had huge political implications because they brought these acts to the forefront of legal debates and made headlines. So nowadays, anthropologists propose the existence of a third category of iconoclasm, that of economic iconoclasm. And what do we mean by economic iconoclasm? Actually, the destruction of cultural heritage for economic reasons, for developing mines and other economic activities. So as an example, I'm referring to the development of a copper mine in Mezainak, in Afghanistan, where the Afghan government has signed an agreement with a Chinese state corporation for developing a copper mine. Unfortunately, this site, which includes Buddhist artifacts, will be destroyed in order to develop this copper mine. So in a way, even though certain cultural artifacts are destroyed, anthropologists suggest that in a way there is a sort of eternal presence in their absence, in the sense that if we look at how the Bamiyan Valley is protected, we see that actually it was listed in the World Heritage List after the destruction of the Buddha's statues. So in a way, there is a sort of eternal presence of these artifacts. As a matter of law, in legal terms, the Bamiyan Valley is protected despite the destruction of the Buddhas. So, after having seen the different types of iconoclasm, now it's the time to see how international law addresses this problem. And of course, as Professor Francioni has already given a brilliant outline of the topic, I will focus on the aspects that can be of particular interest. So as mentioned, international law includes different branches, so it has developed. And so it's very interesting to look at how each of these branches address iconoclasm. Each of these branches of international law protects cultural heritage, or at least governs certain aspects of cultural heritage protection. Therefore, indirectly, it also governs iconoclasm. So, by examining how international law deals with iconoclasm, actually two questions arise. The first one is whether international law is a unitarian system or whether it is fragmented. And the second question that is more relevant for our discourse today is whether international law provides effective protection to cultural heritage. Let's consider how each specific branch of international law governs cultural heritage and can protect it against iconoclasm. Professor Francioni has already explained UNESCO's role in protecting cultural heritage, so I will be very short in providing you with this overview. of course, of fundamental importance are the 1954 Hague Convention for the Protection of Cultural Property in the event of armed conflict, the 1970 Convention on the means of prohibiting and preventing the illicit trade of cultural property, the 1972 World Heritage Convention. UNESCO can also receive specific mandates to protect cultural heritage. So, for instance, after the destruction of the Buddhas in Bamiyan, Afghanistan has signed a memorandum of understanding with UNESCO in order to protect its cultural heritage. But of course, if we look at each of these conventions, we will see that there are specific pros, but also pitfalls in the way these specific instruments protect cultural heritage. Professor Francioni has already illustrated the major merits of the Hague Convention, in premise the idea that it's the first international treaty focusing exclusively on the protection of cultural heritage in the event of armed conflict. However, the Convention is not deprived of pitfalls. So, for instance, it should strike a balance between the protection of cultural heritage and military necessity. However, it includes a number of exceptions in order to take into account military needs. It has vague provisions, no enforcement mechanism. Nowadays, it has been complemented by 2 protocols. With regard to the World Heritage Convention, it has major merits. It has almost universal ratification. However, it has some pitfalls as well, in the sense that it sometimes neglects the human dimension of cultural heritage. It favors top-down approaches to cultural heritage protection. Sometimes it forgets the linkage between local communities and their heritage. More fundamentally, the World Heritage Convention offers substantive overreach and procedural underachievement, in the sense that despite the many provisions it has, it lacks enforcement mechanism, it lacks a dedicated court, and it gives states a wide margin of appreciation as to how to implement their obligation. Finally, by adopting a listing approach, it risks neglecting significant cultural sites which are not enlisted, despite their significance. Of course, other branches of international law also touch upon the protection of cultural heritage, including human rights law. Human rights law forces us to ask, why do we protect cultural heritage? And of course, the answer given by a previous speaker is, we protect it because of its linkage to human beings. So there are a number of provisions in human rights law which protects human rights and therefore the linkage between human beings and their heritage. Of course, there is also another important branch of international law which deals with the protection of cultural heritage, that is international humanitarian law. And I will not add much because, of course, we have one of the top experts on the linkage between the protection of cultural heritage during armed conflict, Professor Roger O'Keefe, so, who will be addressing this linkage afterwards. Of course, also international criminal law, that is an important branch of international law, deals with the protection of cultural heritage and can help in the fight against iconoclasm. In the aftermath of Second World War, even during the Nuremberg trials, there were cases in which accusations of destruction of cultural heritage were made. Nowadays, there have been a number of judgments and cases adjudicated before international criminal courts and tribunals. So the most recent case is, of course, the Al-Mahdi case, and I will not spend more words on this case because, of course, we have here Professor Riyad, who will be discussing this case later. So these tribunals constitute revolutionary innovations because they illuminate the role of non-state actors in the destruction of cultural heritage. So, lastly, also international economic law can help in the fight against iconoclasm. The first aspect is to be considered is that the mantra is that by promoting economic cooperation, international economic law instruments also promote peaceful and prosperous relations among nations. More concretely, international economic law can somehow help stop the traffic in illicitly excavated cultural artifacts. So the UN Security Council resolutions require states to fight this illicit trade. However, as we know, international economic law often lack reference to non-economic concerns, and it risks fostering economic iconoclasm. So, in a way, to conclude, is international law a unitarian system or a fragmented one? Is there a conflict or coherence between these different branches of international law? As a matter of fact, there can be mutual supportiveness between these different branches of international law. For instance, international criminal law can offer a way to enforce specific provisions of international cultural law, and of course other links can be established. However, the protection of cultural heritage is not as effective as it could and should be. So further reflection is needed in order to promote effectiveness. And I argue that holistic approaches are needed in order to build bridges among these different branches of international law and foster institutional cooperation. Thank you for your attention.
Good morning, ladies and gentlemen. My name is Gilles Dutertre. I am senior trial lawyer at the International Criminal Court, and I have led the first case ever prosecuted at the International Criminal Court in relation to the destruction of cultural property. And I am particularly thankful for this event that has been organized by Hélène Toscano, Friends of Florence, the University and the City of Florence. And we are very grateful for the invitation sent to the Office of the Prosecutor of the International Criminal Court. I think it's the perfect forum to be able to share experiences, ideas, practices, and boost our respective motivation in that field. It's all about synergy, and we need to enhance our cooperation in that regard. As you all know, the International Criminal Court is the first permanent international tribunal. It has started its work in 2004, based on the Rome Statute, which created it. And ever since, it has completed several cases for war crimes, crimes against humanity, going about murder, rapes, but also destruction of cultural property. And I'm referring to the Al-Mahdi case, which was mentioned previously. In this case, the accused, Mr. Ahmad al-Faqi al-Mahdi, was charged for directing an attack against 10 monuments in Timbuktu in 2012. And he was recently convicted last December. He cannot appeal anymore. The delay to do it is over, and he did not appeal. So that's a definitive judgment. And we are very happy of the outcome of his judgment. What I want to tell you today is the role we have played on the field of the protection of cultural heritage, and I will heavily refer to this case that I just mentioned. And I will also try to present you briefly the arsenal, the legal arsenal at the disposal of a court to initiate prosecution in various situations in the future. And you will see that even though the court has no geographical jurisdiction everywhere, there are limitations in terms of geographical jurisdiction. When the court has jurisdiction, then she has a full arsenal to apply to prosecute people who have committed crimes, be it looting, destroying, or pillaging cultural heritage. But before I do that, I want to start quoting Fatou Bensouda, the chief prosecutor of the International Criminal Court, and make some quotation of statements she has made in relation to the Al-Mahdi case. And this is important to understand why we decided to prosecute this case, to show how it is part of our global strategy to address crimes that are of concern to the whole international community, and to show the determination of the court in this field. So let me start with the first quotation that Fatou Bensouda made. Quotation: "What is at stake here is not just walls and stones. The destroyed mausoleums," and she's referring to Timbuktu, Mali, 2012, "were important from a religious point of view, from an historical point of view, and from an identity point of view. Such an attack against buildings dedicated to religion and historic monuments falls into the category of crimes that destroy the roots of an entire people and profoundly and irremediably affect its social practices and structures. This is precisely why such acts constitute a crime under the Rome Statute." Later on, Fatou Bensouda made another statement referring to the gravity of the acts made by Ahmed al-Faqi al-Mahdi in Timbuktu. And she stated, quotation, "The loss was not locally confined. The magnitude of the loss of such irreplaceable physical embodiment of history and culture was felt by the whole of humanity and at the expenses of future generations." And I remind you that the mausoleums that were destroyed in Timbuktu were not only important for the local community, there were most of the mausoleums were registered on the World Heritage List. And this explains why Fatou Bensouda has made it a priority to prosecute such crimes, because it is also essential for the world to gain more awareness about the grave danger that such acts pose to the international community. Because let's make no mistake, these buildings are not destroyed for the sole sake to destroy buildings. They are destroyed for what they represent, for the purpose they serve, and for the importance that the local communities give to them. I'm turning now to the Al-Mahdi case and what we have done in that case. As you all remember, in 2012, an armed conflict started in Mali, and various groups, the Mujao, Al-Qaeda in the Islamic Maghreb, and Ansar Din, took over the north of Mali and started to rule the main city of Gao, Kidal, and Timbuktu. In doing so, they applied their strict interpretation, radical interpretation of religion, and everybody could see the brutality with which the population was treated, including with flogging, amputation, and stonings. And in this context, the armed groups in Timbuktu, that is Hakim and Ansar Din, decided to destroy the mausoleums. They used pickaxes, in some cases they used a bulldozer, and they left nothing. All the mausoleums were destroyed, and left the population with nothing. These mausoleums were hugely important to them. They were the expression of their identity. They were going to pray every day at these mausoleums. This was part of the functioning of the society in Timbuktu. In July 2012, the government of Mali referred the situation to the court, and sometime after we started to investigate. We investigated all sorts of crimes, murder, rape, but also the destruction of these buildings. It was quite difficult because the situation on the ground was extremely dangerous. And let me give you an example. It's not related to the work of the court, but it shows really, it was extremely difficult to go to the ground, conduct mission, and interact with witnesses. In 2014, one doctor, a Malian state national, was abducted by Hakim, and he was beheaded just because he was cooperating with the United Nations in Mali. So fortunately, nothing never happened to our own witnesses. But it means that we had to be extremely cautious when going to the ground, when we were approaching witnesses, and when we were trying to collect evidence. And as a matter of fact, we relied a lot on forensic evidence, satellite imagery, videos, rather than on statements of witnesses. After all our efforts, we finally issued an application for an arrest warrant against Ahmad Al-Faqi al-Mahdi. He was arrested in 2015 in September. I don't know, I cannot speculate what he had in mind, but for sure we had overwhelming evidence against him, and in the end he decided to plead guilty. It made the trial extremely short because just a year and 2 days after, he was convicted by Trial Chamber 8 of the International Criminal Court and sentenced to 9-year prison. There is something very satisfactory in this process, and it is the following. In the course of a trial in September, not only the accused pleaded guilty, but he also expressed remorse, and he called for other people around the world not to follow his example in Timbuktu in 2012. For sure, it has a huge impact, and it is a strong message that was sent to the international community. So that's the first example of a successful prosecution for the destruction of cultural property by the International Criminal Court. And the message is the following. Everybody knows now that it is a crime to destroy cultural heritage. Everybody knows now that you cannot go unpunished if you do such a crime. And everybody knows that other charges for destruction of cultural property can come in the future. And this has a preventive effect. It cannot cure all the situations, but surely it is a strong message sent to the world. And I'm now going to address very briefly, I have 5 minutes left, so it's a bit of a challenge, the arsenal we have to fight against this kind of criminality. You have various kind of tense situations on the ground. Internal armed conflict, international armed conflict, and situations where you have no armed conflict whatsoever. But in all these situations, save we have a geographical jurisdiction, I will come back to that, we can initiate prosecution and prosecute people for what they have done. And we have several texts. Some of them are specific and define crimes of directing attacks against cultural monuments, historic monuments, monuments dedicated to religion. Some other texts are general and they define the crimes of destroying civilian objects. All these tools can be used in the context of armed conflict, be it internal or international. But what happens if there is no armed conflict whatsoever? Are we left with nothing? No. When there is not an armed conflict, we can still prosecute people for the crime of persecution, the crime of humanity of persecution. We need to show that there is a widespread and systematic attack against the population. By attack, I don't mean a military attack, but persecuting people, harassing people. We need to show that it is widespread and systematic. And once we have made all the criteria, we have to show that the building were destroyed because the perpetrators were targeting collectivities for political, religious, ethnic, and other reasons, sort of discrimination. And we can then initiate prosecution in that context. So, whatever the context is, we have a possibility to prosecute people even though there is no armed conflict. But it's not that we can act everywhere. I already alluded to the geographical jurisdiction. At the moment, more than 120 states have ratified the Rome Statute, which created the International Criminal Court, and therefore, we have jurisdiction for any crime within the statute of a court that is committed on their territory. But we have no jurisdiction on crimes committed on the territories of states that have not ratified the Rome Statute. That being said, some clarifications are needed. When a crime is committed on the territory of a state party, you have two possibilities. Either the state will refer the situation to the court, this is what Mali did in 2012, or the prosecutor can initiate prosecutions proprio motu. The prosecutor will have to file an application with the judges who will check that it's not a frivolous investigation that is initiated, but it is still possible and based on proprio motu powers of a prosecutor. This was the case in Georgia, this was the case in Ivory Coast. Now, what happens if a crime, a destruction of cultural property happens on the territory of a state that is not a state party, like Syria, like Iraq? It's not desperate because you have a couple of exceptions where the jurisdiction of a court can be triggered. One of them, and I will only address this one, is the ability of the Security Council of the United Nations to refer the situation to the court. It's possible that one day Syria situation is referred, but it entirely depends on the Security Council. The bottom line is that the court, when it has the possibility, is determined to do its part of the job and to contribute to the protection of cultural heritage. We have done it recently, and we will continue to do it in the future. And we are going to issue very soon in November a policy paper on the use of children in armed conflict. Once that will be done, we will start drafting a policy paper on the protection of cultural heritage. So that will be for next year, and usually we always come up with a draft and we circulate the draft among important stakeholders to get feedback, to create comments and improve the text to end up with the best product. In the end, prosecution is only a part of a global effort, but it's an important part because when everything has failed, then we are left with punishing people with the hope that it will have a preventive effect. And it has a preventive effect on some people. And that can only be done because we work together, because we cooperate together, and the Almaty case is the best example of it. There was a strong cooperation with Unesco, for example. We have Professor Bandarini, who came as a witness and testified about the importance of the cultural heritage in general and the process of registering the cultural heritage in Timbuktu. While we were prosecuting, the buildings in Timbuktu have been rebuilt. So it's a best example of synergy, cooperation, and that we can achieve together something in the interest of the whole international community. I thank you.